Зараз розпочинаємо крайній брифінг на сьогодні на тему, як звільнити судову систему від політичного впливу. Я запрошую до слова народного депутата від партії Batkivshchyna Альону Шкрум, Роману Kuybіду, експерту судової групи РПР, та Mykhaylo Zhernakova, суддю Вінницького апеляційного суду та відповідно експерта РПР. Колеги,
Colleagues, you're invited. They authorized me to begin. Right now, they begin the meeting of the working group that was supposed to develop an agreed approach to the law on judiciary and the status of judges. And you add a new, but the details about that will be provided by my colleagues, but I would like to emphasize the importance of those changes that are supposed to happen according to public opinion poll. The majority of citizens of Ukraine believe that this reform is one of the most important that must take place together with the anti-corruption reform. At the same, also the president in his statements underlines that without anti-corruption and judicial reform, other progress in other reforms will be, in fact, impossible. In addition to that, experts agree with that. If we look at judges, they believe that a lot of judges believe that there is no need to change anything. If something, there shouldn't be any radical reform, just some little minor things. This is where we are different. We see the difference between judges and citizens and expectations of citizens. But there are a lot in common here. The main common thing where people agree, and experts agree, and judges, is that what should be a priority of the judiciary reform. We need to get rid of political influence. Of course, people speak about a corruption fight. That is one of the priorities. The judges don't speak about that. What unites these three groups is getting rid of political influence. If the judicial reform doesn't solve this issue, it will not be a judicial reform, in fact. Experts of RPR developed a formula of the reform of judiciary, which includes 9 points. Getting rid of political influence of president and cabinet of ministers. That point 1. Which should take place during this reform. Judicial reform must create conditions for real influential self-governance of judges, for them not to hide, but to be responsible for what is happening in the system. So providing more opportunities, more authorities for judicial self-governance. This is where we will put responsibility for the situation there. Otherwise, the president will be responsible, or the parliament will be responsible for that those abuses we face in our courts, but also to prevent chaos in courts. We need to think about transparent tools, how to hire judges. There should be a competition, and all draft laws, they are similar in this part. Also, there should be clear reasons for disciplinary responsibility, up to a dismissal from the position for abusing the oath, and that should dismissal should take place not according to the separate political procedure, but only as a result of that disciplinary charges. Simplification of a trial because of introduction of court administration, and also bringing a jury to judge to the court proceeding, to the trial. The trust to judges is very low, and that's why if we involve our people more to cases, and I mean the Institute of Jury, and to participate in the work of qualifying bodies, this is one of the priorities of the reform of the judiciary. The court reform should resolve the issue of proper management of cases in court. People should not, the cases should not be delayed, and the cases should not be sent from one court to the other. The people wanted the cases to be considered. So we need to introduce a mechanism when people come with their claims to courts. If the courts should help them to send those cases to a proper instance if there is any mistake. And of course, we need to introduce the tools that would provide an opportunity to reduce the burden on judges. So e-administration, electronic administration, what does it mean? That communication between court and parties to take place through emails. We will save lots of money from the budget. We don't need to spend money for mail, and also will speed up the process because if you send by mail, it takes 3 days plus for return also. But through emails, it takes seconds, and also we need to approach this issue carefully, and we should reduce the burden on courts. It's not just necessarily not for judges, but for citizens, for their cases to be considered sooner. Because if a judge is responsible for 100 cases, they will not even learn about those cases. But if they have as many cases as they can deal with realistically, then it means that they will have enough of attention to those cases as much as needed for them to learn the cases in details. Thank you.
Thank you. Thank you, colleagues, for waiting for us. I will not stay with you too long. Why I'm in a hurry? Because now in a few minutes the meeting of the working group will start on the basis of the legal committee. The more than 100 MPs are part of that. We see a big desire of the MPs to be involved into this process. More than 4,000 amendments have been submitted, and now the question is how to find consensus, how to make it efficiently, how to make judicial reform realistic but not cosmetic. And myself, as an MP who is the first time in the parliament, I can say that this is what we are afraid of. We do not need the so-called judicial reform, which will change nothing for common people, because then it will be the biggest failure of Ukrainian parliament. The judicial reform is one of the most important things, as my colleague said, and you can feel it immediately. Any person can understand whether there's an access to court or not. Is the level of life of corrupt judges the same as before? Have the judges changed? Was there any rotation of judges, or can you come to the court and expect for the resolution not in 2 years but in a month? That is the reform that will be seen immediately. And if common people do not feel that, then this will threaten the stability and the trust to Verkhovna Rada. And that is why we're so serious. Today we were considering the draft law on cancelling immunity of MPs and the limitation of immunity. It was not about limiting the immunity, but we voted for submitting to the Constitutional Court the submission on cancelling immunity of the deputies. The reform should be taking place together with the constitutional reform. What we are trying to do now, we are trying to find consensus on principal matters. We have found this consensus with the public, and that is real access to the court, not just on the paper, not just in the law. That is independence of judges. The judge should know that he or she cannot be a political player in hands of the parliament, prime minister, or the president. The judge should be independent, and we do have these mechanisms, and we can do that. The level of qualification of judges is a very important issue, and that is addressed by both draft laws. I believe we'll find consensus here, but these should be realistic steps which will define the level of qualification. This could be the qualification classes or qualification test, exam, that will be independent and will be executed by independent bodies. Disciplinary responsibility and just responsibility of judges. If you cannot dismiss the judge, you cannot make the judge responsible, then the reform will not mean anything, and people will feel it. And besides, the
Знаємо, що фактично він у нас зараз закріплений, але не функціонує і не
support of the jury is important. I believe that with the support of civil society and my colleagues, this will be done. As to procedure, the procedure of implementation of the draft is as important as the content of the draft law. I say that we are absolutely against cosmetic changes and cosmetic judicial reform. This should be a realistic judicial reform, and the realistic reforms are not implemented in one day or 1 week. Now more than 100 MPs are part of the working group, more than 4,000 amendments. Every amendment does not coincide with conceptual vision, what we suggest, and our colleagues, not just from Batkivshchyna party, but from other parties of coalition, we suggest to talk about concept and find compromise in the things where we cannot find agreement. This could be precedental or non-precedental resolutions of the Supreme Court. This could be many different things, but we need to find consensus and develop the concept. Only after that, after we develop the concept of what we want to achieve, only after that we can start working on amendments. 4,000 amendments, and that means about 2 weeks of work of the parliament. This probably would delay the process. So today we suggest to merge unite the amendments, and they are to be united in accordance with the concept. There are about 10 different items there, and then we will consider these amendments in the committee and then submit them to the Verkhovna Rada. The procedure is as important as the content of the draft law. Because if we'll just talk about judicial reform, this is something that we young MPs are against. We will not be voting for cosmetic judicial reform. That's what we went to the parliament for. That is what every party during the election, before the elections, was talking about. And I request the support of the civil society that a real judicial reform cannot be implemented in 1 day. And that is why we are planning to work seriously for 3 weeks, a month, in the working group, in the committee, in the session hall. And we invite all of you to help us, especially to help us explain to Ukrainians how important it is. And that is why we need to work on this reform carefully and long. Thank you.
Mykhaylo Zhernakov, Judge of Vinnytsia Administrative Court. Thank you, colleagues. I agree that judicial reform is important, and amendments should be adopted according to the rules of the parliament, and this work should guarantee quality of the law, because there is a risk that the text of the law, if there are violations of the rules of the parliament and those amendments, if they are considered in a day or two, 4,000 comments. It will be impossible to have a law of good quality. So there is a risk that in the law there will be not important positions, and on the other hand, every comma has meaning there, because the issue of political influence is very important. That's the first task. And I spoke to my colleagues, judges, and we discussed it all the time. There's a big number of judges, and they don't write about them in mass media, who are ready to work honestly, to do their job if there was no political influence, because the judiciary is penetrated with the spirit of political influence, because despite all the changes, they have not taken place. There are a lot of those things which allow political bodies to influence on judges, and our task to take that, to stop that, and not to allow to help the parliament to pass the law which will prevent political influence. Some text of the law, they enlarge the power of the president. He will not have only the power to move them from one to the other court, but also he will be allowed to move them from down up. So he will influence on their career. Why? Opponents or supporters of they said that power is only on the level of the ceremony, and the president just signs up a decree. It doesn't mean that the president decides anything. I would like to read the decision of the High Administrative Court from 2014 July. That's quite a fresh decision, just one paragraph. The decision came into force. It was approved by the College of 5 judges. As judge says, together the law on the status of judges clearly identifies that the final decision on moving a judge to the court is accompanied of the President of Ukraine when the request of the High Qualification Committee of Judges, it just has the nature of recommendation. That's what the court says. If this norm is still there, or if a power of the president are broader, that any court, if the judge disagrees that he is not moved in a year or two, in this case, he will face that experience that the president takes the final decision, and the High Qualification Committee, the body that is supposed to decide on career of judges, and those decisions of they are just recommendations. So we should get rid of this political influence, and that includes also the parliament. The politics should not influence on judges, because at least the Constitution says that we have judicial, legislative, and executive branches. We need to set clear difference between these branches. That's why for the courts to function and to do the function of administering justice, and for the law to be the same for all, we need to get rid of political influences within this constitution. And then there should be amendments to the constitution. Now we need to reduce political influence, and also we should include all those issues that my colleagues mentioned. Thank you. Any question to Romano Mykhaylo, please? I would like to come back to the law about illustration. It's important for the judicial reform. in your opinion, could we stop or suspend this law? Because there was the head of the Venice Commission told that this law is bad. And if Minister Petrenko or some others ignore that, what results will we have? What consequences will we have here? Can courts suspend cases and other right if they can?
I would like to draw your attention to the fact that the main comment of the Venetian Commission was about the two mechanisms, the mechanisms of the law on renewal of the trust to authorities, and the second mechanism is the mechanism of the law on cleaning the authorities, on lustration. It's about depriving the driving license and other things. Now, not a single judge was dismissed, and they're not planning to dismiss a single judge on the basis of the law on lustration. So we have to change the law to cancel the duplication from the law. There should be the inspection, and the result of such an inspection, the judge could be dismissed for violating the oath. But there are no grounds for stopping the procedure of property inspection. And that does not contradict any European standards. The judge should be responsible for what money he or she is living at. If his or her way of living does not correspond to the revenues of that judge, such judge should be dismissed. One thing that wasn't provided by the law was the mechanism of inspecting. I am against canceling such provisions. Yes, did I answer? Talking about the norms, the procedural norms, there's the problem, and there's the problem in many courts of Ukraine, the judges. I will tell you the truth. They do not know what to do with these cases. On the one hand, there's a certain, or there's no procedure when certain people are dismissed without the inspection, and that does not correspond to the European Convention. But on the other hand, there is this law which is to be executed, and the bodies which were making decisions, they were operating within the powers according to Article 18 of the Constitution. As to suspending the case, my position is a personal position. If there's a submission, if both parties have submitted to suspend the case, then the court makes a decision to suspend it or not, or stop it or not. There is another ground if this case cannot be resolved because this case is also considered as part of constitutional procedure. So I know that in such case, they suspend the case till the Constitutional Court issues the resolution. But the decision of the Constitutional Court, if the law is considered non-constitutional, it loses its effectiveness. When the lustration was taking place, certain decision was made, but these norms were effective. So that is a quite complicated procedural issue, but the judges do not know where to go. If you go to the left or to the right, you will be either fired, or this will be the waste bucket lustration, or you could be made responsible. Politically, the issue is not resolved, and the judges do not know what to do because they are the hostages of political influence. And if the law were different, I believe the judges would be more decisive in making decisions. I would like to ask, what do you think? Is the President, the Verkhovna Rada, are ready to refuse from exercising influence on judges, say why yes or why no? And the second question, the Reanimation Reform Package addressed the President with the proposal to meet and discuss key positions to agree on the ideas as to judicial reform. Is there a reply of the President? Talking about readiness, non-readiness to refuse from the mechanisms of influence, it's better to ask the President or the MPs. Unfortunately, the MP disappeared, but it looks like she, as the representative of young generation, is ready for that. When we were talking about political influence, these are very specific things. That's not just the telephone right. The telephone right has always been there and probably will be there. But will the judge listen to these phone calls? If every step in the career of the judge will depend on the decision of the political body, then it's clear the judge will be thinking about how not to how to do it so that it satisfies the one who calls. There are very clear powers, which these are the powers of the President and the Verkhovna Rada to transfer judges. What is meant? It's not just about horizontal transfer, but the career of the judge. If the judge wants to go from the lower court to the upper court, then he has to go via this procedure. And basically, if the President makes this decision, then the President influences this judge or whatever body. And then without the participation of the President, it is impossible to take oaths from judges. But if the President during the year cannot take judges to oath, then why should he have these powers? He's a busy person, and delaying the date or postponing the date of taking to oath to another day is motivated that the President is busy with something else. Why should the judges take oath to the President? Then ridiculous power to sign certificates for judges. Why the President has to sign these certificates to judges, to heads of courts and their deputies? For so many years, the President has nothing to do with appointing the heads and the deputy heads of courts. And the collective of judges elect and the judges for administrative positions. And why the person, the head of the judge, should wait for some signature of the President. They elect for 1 year only. As to the initiative, as to the meeting with the President to discuss all these issues, yes, we addressed the President. Here's the address, which is registered. We have not received any answer. If the President doesn't have time to take oaths from the judges, he will not have time to meet us. But we, as the representatives of Reanimation Package of Reforms, will be again discussing the issue of political dependence at every meeting, with every possibility to influence this process, because the key task of the judicial reform is to overcome these political influences. Fighting corruption, yes, but that is the task for anti-corruption reform. The Anti-Corruption Bureau has to operate. They have to discover the facts of bribery and so on. That is the prosecutor's office which should be working on that, but I have not heard about any successes of the prosecutor's office yet. The situation which would, that there are more situations which could be investigated. There are many of such situations. I have a question on the courts, economic courts. You were suggesting that they should be dismissed, and there were some roundtables where the legal community was against that. Do the experts of Reanimation Package of Reforms, are they ready to listen to some recommendations and to delete such a requirement as dismissal of these courts because they dismiss the commercial courts, because that will affect the time frame for considering the case.
Господарських судів – це не додаткові витрати.
This reorganization is not losses, that's saving money for the budget. Why? Because the commercial courts are considering small number of cases, 3% only. They receive funding, approximately 1/3. They receive as much as administrative courts. If you take the vertical administrative and commercial courts, they consider a dozen times less. And so the economy should be an efficient use of the funds. The price for the case, for considering the case in commercial court is 6,000 hryvnias, and in other courts is just 1,000 hryvnias. 6 times more the state pays for considering these cases by commercial courts. But taking into account the fact that that is not our key requirement, I would forget this topic. Yes, that is the topic for further discussions. I believe we'll continue discussing it. There are many more arguments. It's not just financial argument, the argument which could be used. Such arguments are related to the global experience. Yes, there is such a vertical on the territory of the countries of post-Soviet countries. They are called commercial, the courts of arbitrage in Belarus. But if you take the experience of other countries, these commercial courts are the courts where not just professional judges sit, but the judges who represent the business community. And that is another thing that we'll be offering when considering these commercial cases. The representatives of business communities should participate, not professional judges, but jury.
Уточнення.
Any question? No, thank you very much. Let's call it a day. Tomorrow we'll begin at 9 o'clock with a spokesperson.